Last month, I got invited to testify on behalf of the Democratic senators in the hearings against Samuel Alito. I was given pretty broad license about what I wanted to talk about. And as I focused on it, I realized that the most important constitutional issues likely to come up in the next several years involve presidential power, especially as it relates to the war on terrorism. So I decided to focus my testimony concerning why I thought Judge Alito should not be concerned for the Supreme Court, but his views with regard to presidential power. The reality is that no president in American history has claimed broader, unchecked, inherent authority than what George W. Bush and his administration has asserted over the last several years. For example, President Bush and his administration has claimed the authority to detain American citizens as enemy combatants without complying with the Fourth Amendment requirement for arrest warrants based on judicial approval, without needing grand jury indictments as required by the Fifth Amendment, without needing trial by jury and proof beyond reasonable doubt as required by the Sixth Amendment. The Bush administration, in famous memos authored especially by John Yoo, taken the position that the president has the authority, and his administration has the power to commit torture of human beings in violation of treaties ratified by the United States and statutes passed by Congress and signed by prior presidents. The administration has claimed the authority to create military tribunals in violation of international law and American law. In just recent months, the administration, including the President and the Attorney General of the United States, have claimed the authority to engage in warrantless eavesdropping in violation of federal statutes and the Fourth Amendment. The administration has claimed the authority to detain as enemy combatants non-citizens at a military base in Guantanamo Bay, Cuba. Some of them have been held now for over 4 years. Not one of them has been given any semblance of due process. And so when I was asked to do the Barrett lecture, I was thinking about what to talk about. I decided that the appropriate topic would be executive power, especially as part of the war on terrorism. What I'd like to do this afternoon is develop 3 points. First, I want to explain to you why I think there is an unprecedented threat to separation of powers and individual liberties as a result of the Bush administration's assertion of authority. Second, I want to try to locate what the Bush administration is asserting with regard to the overall scheme and theory of separation of powers. And third, I want to talk about why, from the perspective of constitutional theory and constitutional doctrine, the Bush administration is wrong, and why such unchecked executive authority should be rejected by the courts. Let me begin then in talking about why I see this as unprecedented. Ever since September 11th, I, like probably all constitutional law professors, have given countless talks about civil liberties and the war on terrorism. And ever since September 11th, my dominant theme has been that throughout American history, whenever there's a crisis, especially a foreign-based crisis, the response has been repression. In hindsight, we come to realize that the repression and the loss of liberties didn't make us any safer. And so, over now, it's almost 5 years, I've talked about how the Alien and Sedition Act in 1798, the suspension of the writ of habeas corpus in the Civil War, the laws that were passed during World War I to suppress speech, the internment of 110,000 Japanese Americans during World War II, the suppression of speech and association in the McCarthy era, show us the dangers of taking away civil liberties at a time of crisis, a time like now. And I've tried to liken what's happened in the war on terrorism to all of these prior events that I just quickly mentioned. I'm increasingly coming to believe that the threat to separation of powers and civil liberties now is greater than it's been at any prior time. I don't say this hyperbole, and I don't say it lightly. Surely I'm not saying that there's the deprivation of liberties today like occurred during World War II with the internment of Japanese Americans. But I am saying when you look at what's happening, there's reasons to believe that this is a graver threat, at least to separation of powers, if not to individual rights, than this country has seen. Let me give you several reasons why I come to this conclusion. One is the indefinite duration of the war on terrorism. September 11th, 2001 is longer ago now, meaning the war on terrorism gone on for longer than the Civil War, World War I, or World War II. The President has told us that the war on terrorism will go on long beyond our lifetimes. Chief Justice William Rehnquist wrote a book just a couple of years before September 11th, in which he argued that throughout American history, we've lost rights during wartime that we then get back after the crisis is over. That works when there's a definite end to the crisis. Now, I would still question normatively whether or not the Constitution should be compromised the way it has through American history. But the thesis of Rehnquist's book was that there's a temporary loss of rights, and then rights are restored. But if there's no time, no point of ending of the war on terrorism, it appears that the loss of rights will go on indefinitely. And when you think of it in terms of separation of powers, my primary focus this afternoon, it then means that the increase in presidential power isn't of short duration, will go on indefinitely. A second way in which the current threat to civil liberties seems unprecedented is the secrecy surrounding it. I want each of you to ask yourself a simple question. How many people are now being detained or have been detained as part of the war on terrorism since September 11th, 2001? My guess is that no one in this room knows the answer to the question because the government has refused to tell us that. Until December of 2001, the government was disclosing the number of non-citizens who were being held for immigration violations as part of the war on terrorism. But in December of 2001, just a few months after September 11th, the government stopped revealing that information. And since then, they've never told us the number they are now holding or have held. A couple of years ago, I had the occasion of debating Michael Chertoff. He was for a time the Assistant Attorney General in the Criminal Division. We debated each other. He was just becoming a Third Circuit judge. Now he's best, most infamously known for being the head of the Department of Homeland Security. And I asked him, how many people is the government holding or has it held since September 11th? He said he couldn't reveal that information because it was classified. I said, I'm a simple law professor, but I don't understand how it hurt national security to tell us, is it 5,000, 10,000, 50,000, 100,000? He said the information can't be revealed. No one still knows the answer to that question. Undoubtedly, there are many other things that the government has done that people just don't know about. Take, for example, the warrantless electronic eavesdropping. It went on for years before the New York Times revealed it in December of 2005. We now know that the New York Times had the story for a full year before they decided to publish it. If people don't know, there's no opportunity for the political process to work. Checks and balances through the legislature, through the courts, can't possibly function. A third reason why the threat to civil liberties and to separation of powers is so great now is that many of the violations of rights are going on in foreign countries, outside eyes and ears of the American press, outside the reach of American courts. Let me start with an anecdote from a case that I was involved in last summer, in the summer of 2005. There's a man from Los Angeles by the name of Cyrus Carr. You might have read about him. It was written up on the front page of the New York Times, who went to Iraq to make a movie. He had the misfortune of getting into a taxi that was stopped at a checkpoint. When the trunk was open, they found in the trunk a number of washing machine timers. And these timers could be used in making bombs. So Carr, a passenger in the taxi, as well as the driver, were taken into custody. They gave Carr a lie detector test, and he passed that he knew nothing about what was in the trunk of the car. And I don't know what was in the trunk of the taxi that brought me here today. Probably none of us know what's in the trunk of a car when we get in. They thoroughly investigated him. They told his family in Los Angeles that he had been exonerated. But still, he continued to be held in a military prison in Iraq. Turns out that a cousin of his was a student of mine in an undergraduate class at the University of Southern California. Got in touch with me, and I got in touch with the ACLU of Southern California, and a lawsuit, petition for habeas corpus, was filed on his behalf in Washington, D.C. The petition was filed on a Wednesday. Judge James Robertson in the federal district court there, the judge to whom it was assigned, did what he was supposed to, and he issued an order to show cause. He said the government had until the following Monday to show cause why Carr should continue to be held. On Friday, 2 days after the habeas petition was filed, the government released Carr from custody. Carr came back to the United States. He appeared with Ted Koppel on Nightline. Well, Carr came back and told the ACLU about the man who was in a cell next to him, a man by the name of Nouman El-Kabi. He was not, as Carr was, an American citizen, but El-Kabi was a long-term non-citizen resident of the United States. He spent 10 years living in the Detroit area. Turns out that El-Kabi was working in a building in Iraq and called in sick one day because he had the flu. That day, the building where he worked was blown up. He became a suspect. He was taken into custody. He was thoroughly investigated. He, too, was exonerated, but still he was held in a military prison. The ACLU filed a lawsuit on his behalf. By coincidence, it was also filed on a Wednesday. The judge also issued an order to show cause, compelling the government to show by Monday reasons for holding him. And 2 days later, again on Friday, he was released. Well, my question is, how many others are there, like Carr and El-Kabi, being held in military prisons in Iraq? If it wasn't for the accident of contacts, Carr and El-Kabi could still be in prison in Iraq. They're released just because the ACLU filed a lawsuit on their behalf. There's been so little publicity in the United States about renditions. This is where individuals are taken out of the United States or from Guantanamo and sent to prisons in foreign countries, including countries with a documented history of torture. To the extent that this is going on, it's outside of the scrutiny of the American press. It's outside the jurisdiction of the American courts. Another reason why the threat is so grave is those whose rights are being violated are overwhelmingly from minority ethnic groups and minority races. I don't think it's coincidental that the worst violation of civil liberties in wartime in American history occurred to an ethnic minority as part of a nation or ancestry which we were fighting in a war. The internment of 110,000 Japanese Americans during World War II in what President Franklin Roosevelt called concentration camps. The reality is the racial profiling that's occurred since September 11th, the violation of rights that's occurred since September 11th, has been targeted at a minority ethnic group, making it much harder for there to be the political accountability, the checks that there need to be, that have to be in these circumstances. Finally, I think part of what makes the threat to separation of powers and to civil liberties greater is the personal threat that people feel. It's not abstract. September 11th caused people in the United States to feel fear in a way that no other event in American history had. And when people feel fear, they're much more willing to give up their rights. And so we've seen that the majority of Americans now support the warrantless eavesdropping by the Bush administration. I've had so many of my students say, I don't have anything to hide by the government listening to my phone conversations. The government would be bored if they listened to my conversations. So why shouldn't they be able to listen? I think, as does almost everyone, that it's inevitable that there'll be another terrorist attack on American soil. It's not a question of whether, it's a question of when. And I have no doubt that when that happens, there'll be another rush to enact new legislation, to empower the executive with greater powers, ever harder to have checks and balances, protection of rights, when people feel personally threatened. And so it's for all of these reasons that I do think that the threat to civil liberties and civil rights, the threat to separation of powers, is as grave now as it's ever been. So I want to move to the second part of my remarks, and I want to talk about where the Bush assertion of power fits within the theory of separation of powers. What's important to recognize is that overwhelmingly the Bush administration has defended its actions as based on inherent authority of the president, primarily based on the president's power as commander-in-chief. You can go through the specific things the administration has done and go back and read the defenses that were given, and you see this time and again. The authority to detain American citizens as enemy combatants is very much based on this. Except for President Lincoln's suspension of habeas corpus during the Civil War, something the Supreme Court later expressly declared unconstitutional. No other president in American history has claimed the authority to detain an American citizen as an enemy combatant without the judicial protections of the Constitution. Jose Padilla was apprehended at Chicago O'Hare Airport in May of 2002. Though we're now nearing 4 years that he's been in custody, still no judge has issued a warrant for his arrest, no grand jury has indicted him, no jury has ever tried him, no jury has ever convicted him. The Bush administration claims the authority to hold him indefinitely as an enemy combatant based on the president's inherent powers and authority as commander-in-chief. Same thing with regard to torture. If you go back and you read the memo approving torture by the American military, written by Berkeley law professor John Yoo, he has to deal with, of course, the fact that the United States ratified an international treaty prohibiting torture, and Congress adopted a statute to implement that treaty. And what Yoo said in the torture memo is that the president, as commander-in-chief, has the authority to authorize torture even in violation of treaties and statutes, that the president has inherent power to do this that neither treaties nor statutes can limit. Indeed, in just the fall of 2005, Professor Yoo published a book where he develops this theory of broad inherent power even to violate treaties and statutes. And of course, we've heard the same defenses with regard to the warrantless electronic eavesdropping that's been revealed over the last few months. The President, Attorney General Gonzalez, have said that the President has authority in part based on Congress having approved a resolution authorizing military force, and in part based on the President's inherent powers. I think the argument that the authorization for military force permits warrantless wiretapping is a frivolous argument. The authorization for military force was just that, saying that the United States government could use troops and other forms of military force to deal with the threat that was posed by terrorism after September 11th. None other than Senator Tom Daschle, who was the minority leader of the Senate, wrote in an op-ed piece in the Washington Post that it never occurred to Congress that they were authorizing something like warrantless electronic eavesdropping. Besides that, to the extent that the electronic eavesdropping violates the Fourth Amendment, then Congress, even if it was authorizing military force, surely couldn't permit a violation of a constitutional right. The other defense that the President and the Attorney General have given is that it's the President's inherent authority as Commander-in-Chief that permits the President to engage in this eavesdropping. The reason they need to make this argument is there's a federal statute, the Foreign Intelligence Surveillance Act, adopted in 1978, that prescribes procedures for gaining warrants when intelligence gathering is the goal. Rather than having to follow the usual procedures for getting warrants, under Title III of the Omnibus Crime Control Act of 1968, the FISA statute creates special procedures that make it easier for the government when the goal is foreign intelligence gathering. And the government almost always, and I mean really almost always, gets what it wants under the FISA statute. The FISA court grants over 99.5% of all of the government's requests for warrants. The FISA statute says, though, that it's the exclusive means for gathering information when its intelligence is the goal. There's two federal statutes that provide the ability to get wiretap warrants, Title III in the FISA statute. And FISA says, this is it, there isn't anything else. So the only way the President can claim authority to do this is by saying it's the inherent power of the President. Well, how should we think of this claim of inherent power of the President? It raises a profoundly important question about separation of powers. When can the President act without express constitutional or statutory authority? I'd suggest that if you read the Supreme Court cases over the course of American history, they don't provide a consistent answer to this question. In fact, I can find cases that suggest 4 different answers to this question. And one of these is that asserted by President Bush. But it is important to put their assertion in the context of all of these cases. One answer the Supreme Court has sometimes given is that the president has no inherent power. The president lacks any authority to be able to act without constitutional or statutory permission. Justice Hugo Black's famous opinion in Youngstown Sheet and Tube versus Sawyer took this approach. You might remember that Youngstown involved President Truman seizing the steel mills as part of making sure that there was steel production during the Korean War. The Supreme Court declared this unconstitutional. Justice Black wrote the majority opinion. Consistent with his view as a textualist, Justice Black said, the president can act only if there's authority enumerated in the Constitution, only if it's spelled out by a statute. And Justice Black said it wasn't here. He rejected the idea that the general authority of the president as commander-in-chief would provide a basis for such actions. There's real problems, though, with this first approach that there's no inherent power. It's inconsistent with how the presidency has functioned throughout American history. There's so many things that presidents do and need to do that aren't enumerated in the Constitution. The Constitution says nothing about who can recognize foreign governments. It says nothing about how cabinet officials or others are removed from office. So while it's a pure position, and there's some authority for it, it's not a very viable one. A second answer to the question, when may the president act without inherent constitutional or statutory authority, is that the president may exercise inherent powers until and unless the president interferes with the powers of another branch of government. That the president can act without constitutional or statutory authority unless the president is usurping the powers of another branch of government, preventing another branch of government from carrying out its duties. I'd suggest to you that this is the approach that the Supreme Court took in United States versus Nixon, the famous Watergate tapes case in 1974. You might remember there the Watergate special prosecutor subpoenaed tapes of White House conversations to use in the prosecution of those who have been involved in the Watergate cover-up. President Nixon asserted executive privilege and the authority to keep the tapes secret. The Supreme Court unanimously, in an 8-0 decision, ruled against President Nixon. And the Supreme Court emphasized that the president has executive privilege, but it's not absolute. As you know, executive privilege is nowhere mentioned in the Constitution, so this is a recognition of inherent power. But the Supreme Court said the executive privilege must yield where there's an overriding need for the information. The Supreme Court said that Nixon's assertion of executive privilege would interfere with the ability of the courts to function, to carry out their duty of providing fair trial. Fair trial requires all available evidence, and thus executive privilege had to yield to the need for evidence to criminal prosecution of those involved in the Watergate cover-up. United States versus Nixon very much stands for this idea. There is inherent power, but only until the president interferes with the powers of another branch of government. There's a third possible answer to the question, when may the president act without express constitutional or statutory authority? And that's that the president may act until and unless Congress disapproves the action. This approach would say it's primarily for Congress, not for the courts to be checking the president. Here, too, I can find some authority for this approach. Supreme Court case in the 1970s, Goldwater versus Carter, would provide some support for this. You might remember what was involved here was President Carter suspended, actually rescinded the United States treaty with Taiwan as part of recognizing the People's Republic of China. Senator Barry Goldwater sued and said, just as the Senate has to approve a treaty, so should the Senate have to approve rescission of a treaty. And the Supreme Court ordered the case dismissed. And a key opinion, a fifth vote for the majority, was written by Justice Lewis Powell. He said the courts should not get involved until and unless Congress gets involved first. He says if Congress wants to disapprove this, then it's appropriate for the court to get involved. But otherwise, the judiciary should stay out of it. It is a notion that the check should be mostly through the legislative branch, not through the courts. There is a fourth and final answer to this question, when may the president act without express constitutional and statutory authority? And that's that in some realms, the president has inherent powers that Congress cannot limit. This is the notion that there are inherent powers And they're powers that cannot be checked by Congress, or for that matter, the courts. I can find only one Supreme Court case that's ever taken this position, a case called the United States versus Curtiss-Wright Export in the mid-1930s. Congress passed a resolution authorizing the president to suspend munitions sales to two countries that were engaged in a border dispute in South America. And a challenge was brought to that on the grounds that it was an impermissible delegation of legislative powers. There was a time when the courts were limiting Congress' ability to delegate powers. And the Supreme Court, in a very famous opinion, said that foreign affairs are different than domestic policy. That when it comes to domestic policy, the states gave power to the federal government, but that the powers of the executive when it comes to foreign policy precede the Constitution. There's a need for the president to be able to act with secrecy and dispatch. The president needs to be able to act in a manner unchecked by the legislature. Well, if you think about it, the assertions of executive power by President Bush can be sustained only if one takes the fourth of these four approaches. I mean, take, for example, the authority to hold American citizens as enemy combatants, or the authority to engage in warrantless wiretapping, or the authority to engage in torture. Certainly, the first approach doesn't support these, for the first approach says no inherent power. The second approach doesn't support these because in each instance, the president is usurping the powers of another branch of government. With regard to detentions, the president is claiming no less than the authority to unilaterally suspend the Fourth, the Fifth, and the Sixth Amendments. With regard to wiretapping, the president is claiming the authority to suspend the Fourth Amendment and not needing to get a warrant approved by the courts. With regard to the torture memo, the president is claiming the authority to unilaterally rescind a treaty and a federal statute. And that does obviously usurp legislative power. Nor can you justify the president's actions under the third model that says the president can act until and unless Congress disapproves the president's conduct. For in each of these instances, Congress has acted. Congress passed a statute, 1971, signed by the president, called the Non Detention Act, that says that American citizens can only be detained pursuant to act of Congress. This was adopted specifically to make sure that the tragedy of the Japanese internment was never repeated, to make sure that any detention had to be by act of Congress. I think it's a stretch to say that the authorization for military force permits the president to detain American citizens apprehended in the United States as an enemy combatant. If nothing else here, I think one could apply the doctrine of constitutional doubt to say that the statute doesn't provide authority. The doctrine of constitutional doubt says if there's ambiguity about a statute, it should be interpreted in a way to avoid constitutional doubts. Certainly there would be constitutional doubts as to whether the resolution authorizing military force permits detaining American citizens without complying with the Fourth, Fifth, and Sixth Amendments. To avoid the constitutional doubts, one would interpret the statute to not permit that, to say at the very least, if Congress wants to authorize detention of American citizens and enemy combatants, it should have to say so expressly. And no one claims that Congress has done so here. So the president's authority to detain American citizens and enemy combatants has to come, if at all, from the president's inherent powers. And the same is true, of course, with regard to the electronic eavesdropping. The electronic eavesdropping isn't authorized by any specific statute. It violates a statute. So if the president can do it, it has to be based on the inherent powers of the president. It's not surprisingly, then, that those who defend what the president has undertaken since September 11th have asserted broad inherent powers of the president. Again, here I'll refer to the book written by Berkeley professor John Yoo and published in the fall of 2005. He says specifically that the framers of the Constitution meant to give the president the kind of powers that the king exercised with regard to foreign affairs, and that the president does have an inherent authority in all of the areas that I've just alluded to and discussed. Well, what about that thesis? What about this fourth model of presidential power? That brings me to the final part of my remarks, where I want to argue that the Bush administration's assertion of unlimited presidential power in the area of foreign affairs is inconsistent with what the Constitution is all about. There's many different ways of arguing that the assertion of power by the Bush administration violates the theory of separation of powers and the doctrines that the Constitution is founded on. One way I could do this is by making an originalist argument. Now, I'm a skeptic of originalism. I don't believe that we can ever really know what the framers of the Constitution intended long ago. As Dean Perschbacher alluded to, I spent 2 years in Los Angeles chairing a commission to write a new charter for the city. And what I found inevitably would happen is we would take tentative votes, come back 2 weeks later, and we all disagreed about what we had voted on earlier. All the time now I get calls from, say, the mayor's office or the city attorney's office saying, what did you mean by this provision? Almost inevitably, the questions are ones that we just never thought about at the time. And what I discover is, if I do have some recollection. If they agree, they say, would you write a declaration? And if they disagree, they keep calling other commissioners until they get the opinion that they want. That was something that occurred between 1997 and 1999. All 15 of us who are on the commission are thankfully still alive. When you start imagining, well, what did the framers intend in 1787? Especially, what did they intend for a world they couldn't have possibly imagined? I don't think originalism is very viable as a theory. It's an aside, but you might have seen that just 2 days ago, none other than Justice Antonin Scalia said that those who are not originalists, those who believe in a living constitution, are, and I quote, idiots. I will plead guilty to being an idiot then. Of course the Constitution has to be a living document. Who would want to be governed by a dead document? But since those who defend the Bush administration pride themselves on being originalists, I'm glad to argue this one on their turf. John Yoo says that he's making an originalist argument for presidential authority. And I think that if there is any place where framers' intent is clear, it's that the framers did not want to create a king or give the president the prerogatives that the king had possessed. After the Revolutionary War was successfully fought, those who later became framers created the Articles of Confederation. The Articles of Confederation didn't have a president or a chief executive. The reason was they were so distrustful of executive power. As we all know, the Articles of Confederation proved unworkable in practice. There was a need for some executive power. There was a need for a federal judiciary. There was a need for a Congress with the power to tax, the power to regulate commerce among the states. But even at the Constitutional Convention, there was great distrust expressed of executive authority. Pierce Butler, one of the delegates at the Constitutional Convention, proposed giving the president the authority to wage war. And that was rejected. In fact, George Mason, another delegate at the Constitutional Convention, said, and I quote, "We cannot trust the president to be able to wage war on his or her own." And the authority that had been proposed, that John Yoo now finds in the Constitution, was expressly rejected. Now, John Yoo says that when Article I, Section 8 provides that Congress can declare war, all that means is that Congress can proclaim that there's a war. He said that he believes, and I'm not caricaturing or misleading you, he says that the president has the authority to wage war unilaterally, and Congress gets to decide whether to call it a war. That's my reaction too. That leaves almost nothing to Congress's power under Article I, Section 8 if all of this authority goes to the president. Now, John Yoo also draws a distinction between total wars and lesser wars, but that's a distinction that has no authority in the Constitution. And in fact, other provisions of Article I, Section 8 make clear that Congress is to be involved even in actions less than a total war, whatever that is. Article I, Section 8 says that Congress can issue letters of marque and reprisal. This is Congress authorizing private ships to take over belligerent ships in times of war. That's less than total war, but still the framers wanted to make sure that Congress would be involved. The framers were so distrustful of executive power. There's so much other evidence as well that suggests that the framers would recoil at the thought that the president could exercise the kind of authority that a Model 4 approach to presidential power would bestow on the president. After all, to go back to Justice Sutherland's opinion in Curtiss-Wright that the president has authority with regard to foreign policy apart from the Constitution, if that's true, why is foreign policy discussed in the Constitution at all? The Curtiss-Wright theory is that foreign policy comes from being a nation. It's only domestic policy that's governed by the Constitution. Why then does the Constitution set rules with regard to how ambassadors are appointed, how treaties are ratified, how war is declared, and everything else with regard to foreign policy? There's a second reason why I think Model 4 is wrong and the Bush administration is incorrect, and that goes to a structural argument. I think one of the most important kinds of constitutional argumentation, and one of the most overlooked, is based on the structure of the Constitution. We've all studied McCulloch versus Maryland. I think part of the genius of John Marshall's opinion there was reasoning from the structure of the Constitution to conclusions about Congress's powers and limits on what states can do. Even before John Marshall ever got to discussing what the necessary and proper clause meant, he talked about under the structure of the Constitution itself, Congress could choose any means not prohibited by the Constitution to carry its authority. He found a limit on the ability of the state to tax the Bank of the United States, not from some clause in the Constitution, certainly not from framers' intent, but from the very structure of the Constitution itself. Well, I have a simple thesis for you about what the structure of the Constitution provides with regard to separation of powers. The framers wanted to make sure that for any major government action, at least two branches of government had to be involved. To adopt a law requires involvement of two branches of government. Even if Congress can override the president's veto, still always two branches of government are involved. Two branches of government are involved in enforcing any law. The executive has to bring a prosecution, but the court has to convict. Two branches of government are involved with regard to appointments of ambassadors or federal judges. The president, but the Senate has to confirm. Same thing with regard to cabinet officials. Two branches of government are involved for major actions in foreign policy. The president can negotiate a treaty, but the Senate has to ratify the treaty. Certainly this is true with regard to war. I think that the framers quite intentionally said, well, the president is commander-in-chief and gets to decide how to use the troops. Congress has to declare war. This isn't profound. It's the genius of a system based on checks and balances and separation of powers. The problem with the Bush administration's assertion is it would make laws that limit presidential power unconstitutional, and it would deny the courts of the ability to check executive authority. With regard to detentions, it's the assertion of the administration that they can detain American citizens and any combatants, notwithstanding the existence of a federal statute to the contrary, because the president is commander-in-chief. With regard to torture, there is a treaty and a federal statute prohibiting torture, and yet the infamous torture memo says the president as commander-in-chief can ignore those. With regard to the warrantless eavesdropping, the president is claiming the authority to do this without needing any judicial approval. If you accept my simple thesis with regard to two branches of government should be involved for any major action, then you can't accept the Model 4 assertion of the Bush administration of unlimited, uncheckable presidential power. A final reason why I think the Bush administration thesis is wrong is the threat that it poses to individual liberties. I intentionally mention this last because I think it's important to recognize before you even get to individual rights, just with regard to separation of powers, there are fatal flaws in the Bush administration's argument. But separation of powers isn't an end in itself. It's a means to an end. Structure of government is never an end in itself. Structure of government is always a means to other ends. And one need only go back to the Federalist Papers, or even the discussion of separation of powers at the Constitutional Convention. And the notes kept by James Madison note that the framers thought that separation of powers was a key way of protecting individual liberties. James Madison wrote in the very famous Federalist No. 10 that the accumulation of all powers, executive, legislative, and judicial, in the same hands is the very definition of tyranny. Of course, the view was that if any branch of government could exercise unchecked authority, then there'd be nothing there to protect individual rights. We see exactly this with regard to the assertion of power by the Bush administration. Take as an example the assertion of authority to engage in warrantless electronic eavesdropping. The claim is that the president, as commander-in-chief in fighting against the war on terrorism, should be able to authorize electronic eavesdropping without needing to worry about approval from another branch of government or judicial warrant, without needing to worry about the federal statute, the FISA law. Just last week, I was debating a conservative law professor, John Eastman from Chapman Law School, and I said, well, by your theory, can the president also search anyone's house at any time without a warrant as part of inherent power based on the war on terrorism? I'll credit him for being consistent, and he said yes. He said that the president, as commander-in-chief, has to have the authority in fighting terrorism to do searches. Well, notice what this then means. That the president or the president's designees can listen to any of our phone conversations, come in and search any of our homes anytime without needing to meet the requirements of the Fourth Amendment. What then is left of the Fourth Amendment? My follow-up question was, well, if the president can suspend the Fourth Amendment as part of the war on terrorism, why can't the president suspend the First Amendment as part of the war on terrorism? Why then can't the president say, in the name of national security, I'm going to keep the New York Times from publishing this story, or the Washington Post from publishing that story? He didn't respond, but I don't see any meaningful distinction. Once we give the president this authority, then there's no stopping point. Once the president has the authority to designate Jose Padilla as an enemy combatant, why can't the president designate any American citizen as an enemy combatant and hold that person indefinitely? Where is the stopping point once we adopt this kind of authority? Now, there's an argument that says, well, it's different because Padilla is being held on the war on terrorism grounds. But what about the war on drugs? The war on poverty, one of those forgotten wars? Why couldn't people be held as part of those fights as well? Now, I've heard people say, well, it's different because Padilla has ties to a foreign-based enemy. Could any Colombian drug lord or any drug dealer who's alleged to have ties to one be held as an enemy combatant without the need for federal trial as part of that war? Could McVeigh and Nickel just have been held and even executed without trial because they were deemed enemy combatants? Once we give the president this authority, then there seems very little left of civil liberties, of individual rights in this country. I'd conclude then with a quote from the late Justice Louis Brandeis, which seems so appropriate to everything that I've been talking about today. Justice Brandeis, in a famous dissent in Olmsted, said that the greatest threat to civil liberties will come from people who claim to be acting for beneficial purposes. He said, people born to freedom know to resist the tyranny of despots. He said, the insidious threat to liberty will come from well-meaning people of zeal with little understanding of the Constitution. Now, Brandeis never knew George Bush or John Ashcroft or Alberto Gonzalez, but he couldn't have picked better words if he did. Thank you.
Could the argument be made that the legislature is acting with the president in the war on terror? Has Congress passed any statutes post 9/11 saying that wiretapping and detention of citizens and, I forget the third thing, torture, even in the context of the war on terror, simply are illegal?
First, Congress has not passed statutes since 9/11 prohibiting those. But second, I don't think you should need statutes newly adopted in order to accomplish this. I mean, take each of those areas. The Non Detention Act is a federal statute, 1971. It's never been repealed. The torture statute to implement the torture treaty has never been repealed. The FISA statute from 1978 says it's an exclusive method for warrants has never been repealed. So I don't think you need new statutes when there's statutes on the books. Congress could repeal those statutes. Now, I think in some instances, even if Congress passed statutes authorizing what the president was doing, it doesn't resolve the constitutional issue. Because I don't think that Congress, even if it passed statutes, can authorize certain kinds of behavior that would violate the Constitution. But what's striking to me is that in each of the areas that I focused on, there is a statute on the books. That statute hasn't been repealed. We all know that the president can't, on his own, repeal or rescind a statute. So I would say it's not the question of has Congress acted a new law, but has Congress acted to repeal laws that are on the books? And that, I think we'd all agree, they haven't done.
Hello. I was really fascinated by when earlier you were saying that you had students of yours that said, oh, well, I have nothing to hide, I don't really care if people wiretap. That attitude to me is kind of intriguing in the context of culturally what I see going on is kind of a blurring of the distinction between private and public spheres. By that I mean like reality TV, where it's like you have these kind of contrived shows that are deliberately set up where supposedly it's like people are talking about their private personal feelings, but it's really being broadcast. Or I see things where I'm riding on public transit and somebody's having a very heated, what I think should be a private conversation on a cell phone in a very public place kind of thing. And so I hear what you're saying about sort of the underlying question is, why would people be willing to accept that other people could listen in on their phone conversations and think that it wasn't really a big deal? But, and I'm wondering if, it's like part of it is that there is this whole cultural thing that's kind of going on too.
It's tempting to blame all this on Jessica Simpson and reality TV. And you make a good point. And yet my instinct is that's not really what it's about. You might have seen the story, it was on the front page of the New York Times, I think it'll be 3 weeks ago tomorrow, showing that whereas initially when there were the revelations of the warrantless eavesdropping, most people were against it, but it was then that the majority of people were now in favor of it. And you think about, well, why is it? Is it just that we don't have as much of a sense of privacy? I don't think it's that. I think people have a pretty healthy sense of privacy, but I think people also believe that terrorism is really a threat to them in their lives. And I think people are historically willing to give up civil liberties to feel safer. And so that's why I hear from my students, not all of them, not even most of them, but certainly some of them. It's why we see in this article in the New York Times people saying, well, I don't have anything to hide. If the government wants to listen on my phone conversations, the government can do so. And I think if, God forbid, there is another terrorist attack in the United States, I think we all believe there's going to be, I think there will be the desire to even give the government more power to make us safer. And so I think it's that privacy is abstract, the feel of fear is much more tangible, and I think people are willing to give up that kind of privacy, that kind of rights, to feel safer. And maybe it goes to the broader questions of public and private spheres, but I think and I think this is what American history shows, especially in times of crisis, people are willing to give up their rights for the sake of feeling more secure.
I was hoping that you could just talk a little bit about the theory of the unitary executive and how that fits in with the arguments that the Bush administration is making.
Sure. A group of conservative law professors have developed the theory that all executive power in this country must be vested in the president and under the control of the president. Now, that by itself doesn't tell us what the checks can or can't be, though it's interesting that those who take this view also tend to believe that there's executive power that cannot be checked by other branches of government. The reason this came to public attention is that Samuel Alito wrote memos in the 1980s and gave speeches as recently as 2000 saying he strongly believed in the unitary executive theory. Well, this is all so abstract. I think one of the problems for anybody who's watching the Alito hearings is the phrase unitary executive doesn't have any context for most people. It certainly doesn't have any political resonance. But what does it mean specifically? Well, it would certainly mean that it's unconstitutional to have an independent special prosecutor that can't be removed by the president. And Alito gave a speech in 1988 criticizing the Supreme Court's decision in Morrison versus Olson, a 7-1 decision that upheld the independent special prosecutor. It would mean that it's unconstitutional to have commissioners on federal regulatory agencies that can't be removed by the president. And so you couldn't have the Securities and Exchange Commission, the Federal Trade Commission, and so on, with commissioners that the president can't remove. It's unconstitutional by this theory to have any sort of executive tasks performed by state and local governments. In fact, one thing that's often overlooked is in 1997 in Prince versus United States, when the Supreme Court declared unconstitutional the Federal Brady Hand Control Act. We all remember they did so because they said it violates the 10th Amendment for Congress to compel states to administer a federal mandate. But Justice Scalia also said this is giving executive power to enforce a federal law to state governments. This violates the unitary executive theory, the one time that a majority opinion of the courts ever adopted the unitary executive theory. And as I said, those who take this approach tend to also believe that the power that the president has is not subject to checks by other branches of government. And you find this clearly expressed in Justice Thomas's dissenting opinion in Hamdi versus Rumsfeld in June of 2004. The Hamdi issue was whether or not an American citizen apprehended in a foreign country could be held as an enemy combatant, and if so, whether the individual had been given due process. The Bush administration asserted broad executive authority to do this and said no due process required. Thomas was the only justice of the 9 who took the administration position all across the board with regard to what they're claiming. And Thomas specifically invokes the words unitary executive, citing to the law review literature on unitary executive, saying that this is a power of the president. And so the unitary executive theorists tend to very much take the Model 4 approach of the ones that I've said. Now, there are two distinct questions there. One is who can possess executive power? The other is how can executive power be checked? But they tend to get blended in the way the unitary executive theory is being developed right now. And to me, what was of concern with regard to Alito, or one of many things that was of concern with regard to Alito, was his espousing the unitary executive theory at a time when I think we really need the courts to be aggressively checking the president.
Professor Chemerinsky, can you please explain how is the United States then any different than other countries who use Model 4 of the inherent power, like Cuba, Iran, North Korea? How are we different? And we tend to want to claim that we're separate and distinct from these type of governmental entities, but our actions seem to be speaking louder than our words.
I'm not sure I have anything to say in response to the question, because there are so many ways in which our country, despite all that's happened, still is wonderful with regard to freedoms and liberties. I mean, I can stand here and give this speech. Now, in part I can give it because it's completely ineffectual. They can let me say what I want to make a difference. I'm much less sanguine at the point at which they start to feel threatened by progressives speaking like this. But, you know, it's like when the Bush administration developed the do not fly list, my wife wanted to see if I could get put onto the do not fly list. So I'm really cautious about saying, well, we're just like them. But in some respects, we are. I think to the extent we give the president unchecked power of this sort, then we are like countries that give their executive unchecked power. When we talk about torture, then the kind of torture that goes on is as bad as what countries, the worst countries in the world are doing in terms of torturing human beings. You might have seen that new photos came out just yesterday of torture in Iraq. And the administration's response was not, this is awful, we have to stop it, but that this might incite further violence against the United States and these things shouldn't come out. So instead of saying this is a terrible practice, we need to stop it, saying that, well, we need to silence the speaker. There's a report that was issued by the Defense Department last year in 2005 that, I mean, I've actually got in my suitcase the exact quote, but it said that the threats to the war on terrorism are going to come in part from judicial actions, and that the threat to national security is going to come from the courts. Well, saying that the courts can't check the executive then does start to lead to the kinds of abuses that have occurred in other countries. This country has a terrific history of freedom broken up by periods of repression. And what I worry is that we're now in an era of repression that doesn't have a stopping point.
Is there any indication in litigation or any kind of courts that come up in regards to, you said, usurping the Fourth Amendment? How about detaining people and actually finding evidence of other crimes, for example, the war on drugs, and actually turning those, those findings over and prosecuting?
I'm not sure I understand the question.
Well, I mean, if they were allowed to go into your house, for example, and to search, and if they found something that had nothing to do with terrorism, has there been any indication that that could cross over into some sort of prosecution?
I'm going to go back and say, one issue that's going to, I think, need to be resolved is, what about evidence that was gathered as a result of the illegal eavesdropping, and is that then to be excluded from court? There are a number of U.S. attorneys who have expressed concern that some of their criminal cases may be tainted because the basis for the warrant was illegal eavesdropping. The Bush administration is going to take the position, and Attorney General Gonzalez articulated it yesterday, that he believes doesn't matter if it was as a result of an illegal wiretap or illegal eavesdropping, they can still use the evidence in court. I think that's really hard to reconcile with the exclusionary rule. Now, part of the problem in enforcing this is going to be whether the criminal defendant is going to be able to know that the evidence is tainted for that reason, to be able to make a Fourth Amendment challenge. But if you accept the administration's position, and now I can get to your question, and the police, the federal authorities had the right to do it, then anything that they gained while they were there is permissible as well. I mean, there is the well-established exception to the Fourth Amendment for plain view, or plain sight, plain smell, plain touch, that if a police officer is lawfully in somebody's house and they see contraband, then they can seize it as evidence. If Bush is right, Gonzalez is right, that they can, even if they're enter the house, and they haven't taken the position of entering the house, but if they can't enter the house, and that's lawful, then any evidence they get would then be admissible. The key, though, is the premise, is it lawful for them to be there in the first place?
I'm wondering if any arguments have been made. We keep focusing on the warrantless eavesdropping, but for other exceptions, like constitutional exceptions, like exigent circumstances, or if they've ever claimed that they have probable cause for these searches. The Bush administration, and especially Attorney General Gonzalez, have never tried to say that this fits under the exigent circumstances exception to the Fourth Amendment. I think it would be very hard to fit this under the exigent circumstances exception to the Fourth Amendment as that's been defined. I mean, I think you could occasionally, as an emergency, where you justify it as an emergency, but the systematic interception of communications over a long period of time without warrant seems very difficult to reconcile with the notion of exigent circumstances as defined by the court. But the simple answer to your question, and I think everybody on both sides would agree, no attempt has been made by the Bush administration or the Gonzalez Justice Department to defend this based on Fourth Amendment doctrine. It's been entirely based on the inherent powers of the president and the authorization for military force.
I think with that we should thank